Have you moved to London now permanently?
First person to say that, my lord.
I suspect your family might have something to say about it. Right. Well, thank you very much for your note clarifying that we're not going to have to struggle with the criminal causa matter issue. No. Well, that's very, very helpful.
Captured that perfect. I just wanted to bring that to the court's
Well, that's very kind. Yes.
Yes,
That's very sensible. And you'll have seen that we're fully au fait, indeed immersed in this case, because we sat, as we customarily do, to discuss whether to give permission. So we're very aware of the background.
Very quickly.
Good.
The essence of this is that it's the first. There doesn't seem to be an authority that has been cited before the court where a first instance appeal has been restricted in this matter.
Yes.
You may need to. I get the impression that people at the back may be finding it difficult to hear you.
Sorry, my lord. This seems to be the first case where this has been considered in the context of an appeal from a first instance court. It always seems to be a superior appellate court where one has had already one appeal. And so the restriction when one looks at done has been justified on that basis as proportionate because you have already had one appeal. Whereas there's a far greater restriction in this case, we say, which is different from the decision in Dunn for that very reason, and it is a disproportionate restriction on your right of access to an appellate court.
Well, in a sentence, I suppose what you say is that those cases which have addressed the question of access to court have customarily considered that if there is one appeal, that will be sufficient. At least it will fall within the margin of appreciation of the member state as to the adequacy of access to the court. But your point is that here, for the first time, we're dealing with a case where the first instance decision is the only decision.
Yes. And one can see the policy reasons why one may want to restrict a second appeal, but those don't necessarily apply to a first instance appeal. And, and indeed, the perception of justice and I suppose the reputation of the justice system might require that one should have at least one appeal from a decision of first instance.
But I mean, is that a principle of domestic law or a principle of European law that you're relying on?
Well, it's referred to in passing in Dunn, and maybe I'll go to Dunn very quickly what I say are the relevant passages, but that right now, I suppose I raise it in two contexts. One has to look at policy and the reasons for these provisions when determining what the legitimate aim is and in terms of proportionality. But it is also raised in the context of right of access in Article 6. The decision in Dunn is at volume 2, tab 34, begins at MS 762.
Yes.
And at MS 763, the court looked at paragraph 8, looking at the decision of the Court of Appeal, found that the certification requirement amounted to an interference with the applicant's right of access to the Supreme Court, which was, however, justified in pursuit of the legitimate aim of providing a filtering mechanism to control the Supreme Court's caseload. And the Court of Appeal found that the certification requirement amounted to then they quote the decision of the Court of Appeal. Moreover, we do not accept that a refusal to certify amounts to a denial of the essence of the appellant's right of access. The appellant has the right to have his access to the second tier appeal, court decided by an independent impartial tribunal. And then later, about 3 lines in the bottom, he is not entitled to have his case considered by the Supreme Court in circumstances where it is legitimate for there to be a filtering of the cases before that court. And then at paragraph 12 on 764, the Royal Commission is considered, which was chaired by Lord Runciman, was tasked to consider, inter alia, whether changes were needed in the criminal appeals process, and the Commission recommended the abolition of the certification requirement as unduly restrictive to require such a certificate. We think, therefore, that the requirement that the Court of Appeal certify that the case involves a matter of law of general public importance should be dropped. The need to obtain the leave of either the Court of Appeal or the House of Lords before proceeding further is by itself a sufficient filter, and of course this Court would be able to exercise that filter in circumstances as it always does in any civil appeal from the Court of Appeal. So it's not necessary that there is a further filter being exercised by the lower court. And they point out that in Scotland, at paragraph 14, the last line of that paragraph, there is no certification requirement for criminal cases referred to the Supreme Court from the High Court of Judiciary. And at 15, point out that in civil cases, there is no restriction imposed by the lower court.
Does that remain the case?
Yes, I was going to say, it's changed, hasn't it? That has changed. Well, it's my lady who'd be more au fait with it than I.
I have not checked it for today's purposes, but
I will check that and perhaps send a note to the court. Thank you, my lady. Paragraph 22, what the court records the applicant's submissions in Dunn, where they submit that the government had not provided any examples from any other jurisdiction whereby access to the Superior Court was finally determined by a decision of the Inferior Court. And then the court's assessment begins at paragraph 27. And there's no dispute between the parties. Article 6 applies. Paragraph 29, 2 lines down. Nevertheless, where a state does institute appellate courts, it is required to ensure that persons within its jurisdiction enjoy before these courts the fundamental guarantees contained in Article 6. Paragraph 30, the right of access to a court is inherent in the right to a fair trial set out in Article 6. 3 lines down from that. In other words, to ensure compatibility with Article 6, limitations must pursue a legitimate aim, and there must be a reasonable relationship of proportionality between the means employed and the aim sought to be achieved. And 31, the court recalls that it is of fundamental importance in a democratic society that the courts inspire confidence, and that's the point I wanted to get to Lord Parnell. Convention view of that. To that end, it is constantly stressed that a tribunal must be impartial from an objective as well as a subjective point of view. Now, ultimately, the impartiality argument was disregarded by the court in that instance, but in my respectful submission, it must still be a feature of how the court approaches this, a public perception of the justice system. And then,
well, Lord Justice Goulding, I think, made it clear, did he not, that a distinction is to be drawn between a decision on the merits by the Court of Appeal or the Divisional Court and the exercise undertaken by the same court in deciding whether or not a point of law of public general importance should be certified.
Right, it's performing a different function.
Yes.
The argument.
Well, I think it's the decision of Lord Justice Goulding rather than the argument.
Yes, yes, precisely. But having said that, that's correct. That was the decision. But in my respectful submission, it will always be in the back of the public's mind that, yes, it is performing a different function, but in exercising that second function as to whether there's a point of public importance, it cannot be forgotten that will restrict the right of appeal. And that's with no obvious disrespect to the individual involved. It's only a perception argument.
Yes, I see.
But it is still there, although the primary argument is an access to the appeal under Article 6. In my respectful submission, one must be mindful of the perception of this restriction. And the court, then at paragraph 37, referred to Wells. And again, that was a case dealing with a superior court of appeal. It's limited to a narrow category of cases of particular legal importance. There is no appearance of unreasonable or disproportionate restriction on access to court for the purpose of Article 6. And it falls within their margin of appreciation under Article 38. The question then is, how does this court deal with that if there is a restriction on, if Article 6 is breached, if it is a disproportionate restriction on the right of access to an appeal, how does the court deal with it? And we suggest that one looks at...
Can I just begin, before
yes.
we leave done,
Yes.
bears in mind that this is an admissibility decision. The argument was seen to be manifestly ill-founded and therefore inadmissibility by the fourth section. So it's quite a strong case against you on the principle, isn't it?
Only on the principle of a second appeal?
But it doesn't say that. I mean, that's not the ground on which it's put.
Well, in Wells it does say as a superior court of appeal, and in the it does make clear when it refers to at paragraph 9 the decision of the lower court, Goldring, that his access to the second tier appeal court. That's the third line down from the quotation. So it is very specific in dealing.
I see.
That it does deal with a second tier appeal.
Right.
So how, if the court did feel that this was a breach, how would it deal with it? We suggest when one looks at section 41 of the Judicature Act, which is in volume 1 of the authorities at MS 172, that first of all, section 41(2) sets this out, that no appeal shall lie under this section except with the leave of the court below or of the Supreme Court, subject to section 45, which is a habeas corpus provision. Such leave shall not be granted unless it is certified by the court below that a point of law of general public importance is involved in the decision, and it appears to that court or to the Supreme Court, as the case may be, that the point is one which ought to be considered by the Supreme Court. And one could read that in a section 3 way, or even on a plain reading of it, that the word "or" to the Supreme Court may cover both elements of the previous part.
One could, but one would be wrong, because it says it appears to that court or to the Supreme Court that the point is one which ought to be considered by. So the prefatory words, it appears to that court or to the Supreme Court, govern the succeeding words which say that the case is one which ought to be considered by the Supreme Court. I mean, when we're considering whether or not to give permission to appeal, it's a two-stage process. First of all, whether it's a point of law of public general importance. I mean, leave aside certification for the moment. And secondly, whether it's a case that ought to be considered by the Supreme Court at this time. And it may well be that factors such as the certitude of the Court of Appeal's decision, or the circumstance that the Supreme Court has addressed the very question and issue previously, may impel us to the conclusion that we shouldn't give permission, not because there isn't a point of law of public general importance involved, but because of those anterior circumstances. So it doesn't seem to me that there's much profit in suggesting that the Supreme Court, by even a slightly contorted reading of section 41, subsection 2, can arrogate to itself the task of deciding whether or not a point of law of general public importance for the purpose of certification arises.
Well,
but we have your point.
That's the point, that it's one could, and your lordship may regard it as a contortion, but one could look at that sub-paragraph and the court looking at that, could take it upon itself to be able to decide both issues, whether there's a public court or whether leave should be granted. And I accept that they're two completely separate functions.
Well, I think we have your argument on that.
Well, on that paragraph, but I make it again at subparagraph 4 then, my lords,
Right.
for what that's worth.
Let's have a look at subsection 4 then.
For the purpose of disposing of an appeal under this section, the Supreme Court may exercise any powers of the court below or may remit the case to that court. And
Well, the difficulty with that argument is that it's disposing of an appeal. So that surely presupposes that the court is seized of an appeal. At this stage, we are deciding whether or not to give permission to appeal. We're not deciding the appeal. And it seems to me, subject to what you may seek to persuade us of, that disposing of an appeal has to have the connotation that we are seized of the appeal and disposing of it.
there isn't necessarily that restriction of meaning of the word disposal. It's not been the subject of...
No, it's not the word disposal that's the problem. It's of an appeal that I think presents you with the difficulty. Disposing of an appeal. It's not disposing of an application for permission to appeal.
It's also the problem with 2. I mean, no appeal lies to this court.
Yes.
So if you haven't got an appeal to this court, then you've got nothing for 4 to bite on.
Unless this court certifies a question and grants leave to appeal.
So we're back to subsection 2 again.
We are.
Yeah.
I did preface
Well, it's,
that it was essentially the same.
in fairness to you, Mr. Lavery, it's an ingenious argument, but I think we have the point.
I should normally sit down when I hear those words.
We'll give you another 30 seconds or so.
But it's not outside. Your Lordship may describe it as a contortion, but there are many circumstances in which Section 3 has been used to interpret pieces of legislation in a much more contorted way. One is dealing with an appeal, disposal of an appeal. What is the alternative then if the court is not with me on that, but finds that there is a breach of Article 6? We're into the area of a declaration of that section and perhaps Section 35, which is at MS 169, which states that 35.2, no appeal to the Court of Appeal shall lie except as provided by the following provisions of this part from any judgment of the High Court in any matter. So the purpose of Section 3 is to find a convenient route through what would otherwise be difficult exercise of declarations of incompatibility, legislation changes. That's why I suggest that not a fantastical contortion by any means could be applied to Section 41.
Perhaps we can leave contortion to one side.
Yes, sorry.
A matter that occurs to me, Mr. Larry, if we were disposed, and for my part, I certainly haven't decided yet, but if we were disposed to give you permission to appeal on this point, but considered that permission to appeal on the substantive issue should be refused, what course should this court follow?
On the issue of a declaration of compatibility?
Yes.
Well, that may impact upon, well, there may be an appeal at the end of all of that to the Northern Ireland Court of Appeal. If the section restricting an appeal to this court were found to be incompatible,
yes,
and the legislation was changed after that,
yes,
then we may have an onward appeal right.
Yes, yes. So this could be decided as a separate issue.
Yes.
And I wonder if it perhaps ought to be decided as a separate issue.
Yes.
Yeah. Because if you succeeded in this, then, as you say, it would not be appropriate for the Supreme Court to address the substantive issue. Because if you succeed on your current argument,
my lord, yes.
then the consequence would have to be that, well, I'm not sure that it would have to be, but it probably would be, or at least arguably would be, that the appeal would lie to the Court of Appeal.
More appropriate, perhaps, my lord, that this court would be able to exercise the functions of, well, Court of Appeal, but then the Court of Appeal wouldn't have been engaged at all. So
Yes.
I think that would be the better course, my lord,
Yes.
to decide that point separately and then see exactly where the litigation is.
Yeah.
In those circumstances, what's the effect of section 41(1)(a), assuming as I do that 41(2) is not in point?
Yes, well, that any declaration of
Assuming a declaration of incompatibility applied to subsection 2 in material part. Then still be within 41(1)(a), or have I misunderstood? To this court, direct.
yes, subject to restriction in subsection 2.
So if subsection 2 is not a material restriction.
Sorry, my lady.
If subsection 2 is not a material restriction, I see, but leave has been refused.
Well, that's if we contorted subsection 2 in the way you suggest we should. But if we simply declare subsection 2 incompatible, then it would remain as a bar for the time being until Parliament did something about it.
That's what I say is the difficulty with declarations of incompatibility generally, that there'd be a gap for a period of time, which is reliant upon government with its scarce resources to legislate.
Yeah.
Scarce time at the moment.
Yeah. Right. Anything else, Mr. Lavery?
Well, my lord, my lady, the Section 40 of the Constitutional Reform Act gives a wide, what's worth, MS 200. Section 40, subsection 5, the court has power to determine any question necessary to be determined for the purposes of doing justice in an appeal to it under any enactment. It's a broad provision. If there were to be a reading of Section 41 in a way that enabled this appeal to proceed in a substantive way,
Yes.
might be assisted by the breadth of that provision.
Which section is that?
It's Section 40, subsection 5 at MS 200.
But you run up against the same problem in an appeal to it.
Yes.
Yeah. Right.
The argument about running through, as put in our written submissions, the Human Rights Act, beginning with the lower court being a public authority and being in breach of the applicant's rights by failing to 6, 8 and 10, by failing to vindicate those rights, Article 6 by creating restriction of access to a court of appeal, really takes it around in circles again.
Yeah.
But it can't be suggested by the argument that the police, the second respondent, that because the court below hasn't found a breach, that there isn't a breach, and that the public authority itself is not actually in breach.
Yeah.
That's a circular argument. And lastly then, if I may, the argument, just in that context, we say that in the case of Ray and in this case, the court itself has adopted a supervisory jurisdiction. It has looked at the Article 8 interference, Article 10, and formed a view, having performed a balancing exercise. And then if at MS 90, and this is the last point I want to raise, it's an argument raised by, MS 44. This is the argument of the first respondent. This is directly relevant to the proportionality of the provision. At paragraph 21, it's suggested at MS 44 by the first respondent that proceedings before the High Court in a criminal cause and matter are in general incidental to actual or potential criminal proceedings to which the full panoply of protections afforded by the common law and Article 6 would be applicable. And lastly, last sentence in that paragraph, any applicable avenue of appeal within the criminal process will remain available to the person affected. But of course, there are no criminal proceedings here. So
yes, but the point that is being made here is that if criminal proceedings materialise, you will, in the ordinary course, have a right of appeal from any finding of guilt on the part of your client. I mean,
yes.
That's the point that's being made, isn't it?
It's a point that's been made, but it doesn't address the interference, the Article 8 interference, before you ever get to that, and whether there ever will be criminal proceedings.
Sure. I mean, the Article 8 interference is qualified right. Article 8 is a qualified right, and it goes, does it not, to the question of justification. That if you have a filter in circumstances in which the defendant, if he is prosecuted as a result of the conclusion that an appeal to this court is, to use the buzzword, stymied by the provision, then there is a fallback position, namely that you can appeal in the ordinary course.
That's dependent upon there being criminal proceedings.
Oh, absolutely,
And
absolutely. But it goes to it goes into the balance as to whether there's a justification for the interference with Article 8.
In general terms about the provision, but that doesn't act upon this particular case where there are criminal proceedings.
But
I think that's a difficult proposition, quite honestly. I mean, we can't blinker ourselves and lose sight of the fact that if you are going to be prosecuted, at least you will have a right of appeal against any conviction which flows from those proceedings.
The point I'm making is...
I think I've got the point that you're making.
Is that the proceedings won't address any Article 8 issue.
Right. Right.
But you'll be able to say it wasn't a fair trial because the evidence that was relied upon was evidence obtained in a particular case, unlawfully or whatever.
Well, one may be able to say that, but that won't be a complete remedy to the intrusion, which is prior. And as the Lord Chief Justice pointed out in the substantive part, that this exercise of gathering evidence may be for exculpatory purposes as well as inculpatory purposes. It's an information gathering exercise which may or may not lead to criminal proceedings and ought to be the subject of supervision by the court, ultimately, we say. In a case where there are interferences with Article 8 and Article 10, we say, in fact, that there should be judicial supervision of the initial request, the initial ILO request, and it shouldn't just go to the PPS.
Yeah.
That hasn't been looked at. It's only been looked at once by the court.
Yeah.
So in this context, it's the point I'm making, the proportionality argument is far weaker than if there were extant criminal.
Right. Thank you very much indeed. Now, Mr. Cole.
Thank you, my Lord. In light of the submissions that have been made today by our friend Mr. Lavery, I propose to really just try to deal with the domestic law issues in relation to Dunn.
Yes.
My learned friend Dr. McLeanan and I had divided up the labour between us, and he's going to address the court on the convention aspects of that, if that's agreeable with the court.
Right.
So, but I suppose our fundamental point in relation to Dunn is that Dunn does not set down, and particularly I refer actually to the domestic decision in Dunn that you find at tab 25, MS 70, sorry, beg your pardon, MS 697. And Dunn does not provide any rule of law that effectively suggests that it's only acceptable to have this certification filter in the context of second appeals. Yes, Dunn did occur and did arise in the context of a second appeal.
Well, is there any authority which says that whether there is no appeal from the decision of the first instance court, that a certification process is nevertheless acceptable?
Not directly, Lords.
Well, even indirectly.
Well, in the sense that we don't have an authority that categorically says that, but the way we suggest the court should look at that is the court doesn't have any authority to the contrary. And the principles that arise in Dunn are exactly the same, be it a second appeal or a first appeal. But the policy reasoning behind it is exactly the same. I'll come to that now. So in the context of Dunn, there clearly was a second appeal. It's a Section 33 appeal. There had been a Crown Court trial and an appeal to the Court of Appeal. And that, of course, could be the case similarly in the Northern Ireland jurisdiction if the case came through the Crown Court route. In this particular context, and touching upon some of the points that have been raised with my learned friend towards the end of his submissions, we do have in the backdrop, in the widest sense of the phrase, criminal proceedings or criminal cause or matter. There clearly is a criminal investigation underway, and the PPS and the PSNI are involved in that context. The application for judicial review that's brought, while not perhaps with a capital S, is with a small s, satellite from the main aspect of the criminal justice system. So in other words, if it were to be the case in due course that Mr. McIntyre were to be subject to prosecution, then he will have the full panoply of the protections of the criminal law, criminal justice process. And if in fact thereafter he were to be convicted, he would have, all other things being equal, the opportunity to appeal that conviction to the Court of Appeal in the same sense and way as arose in Dunn. So the backdrop to this particular case and the way it comes to this court operates in that wider context. So yes, it is not a second appeal, but it must be seen to operate in the particular circumstances where there is the possibility.
Well, Mr. Lavery's argument is that that is entirely incidental to the rights that his client should enjoy. I mean, if he didn't have to confront the certification procedure, then he would have been perfectly entitled to apply to this court for permission to appeal.
Well,
that is not met by saying, well, it doesn't matter because if you're convicted, you've got a right of appeal.
Lord, if the way we would say the court should look at that is, if in fact there was no requirements for certification, then it would depend how that operates. It may be, for example, if the law were different, that there would be a right of appeal in this type of case to the Court of Appeal in Northern Ireland. Now, that's not the route the Parliament has taken. And by Parliament deciding that the criminal cause or matter appeals from Northern Ireland will derive to this court, it is also cognizant of the fact that this court operates as the final court of appeal in the United Kingdom. So it has
not
to
operating as the final court of appeal in an instance such as this, because it's functus officio, isn't it?
Well, on my learned friend's argument is, of course, that you should say it's not. So if that were to be right...
Yes, but on your argument, it is.
Yes, it's not even functus officio.
Looking at this at all.
It's not even a question of functus officio. It just simply doesn't have a jurisdiction because of the certification requirements. But if the certification requirement were to be the mischief and had to be removed in some shape or form, it still doesn't take away from the fact that Parliament is looking to the appeal route being to this court. And while in this particular case, this court would be acting as the first tier of appeal, that's one way of looking at it. But the other inescapable fact is that even if it were to be the first tier of appeal, it would still be the final tier of appeal.
Yes.
And this court primarily operates in that context. As we know, as the Supreme Court, it is the final port of call within the domestic law setting. So in that context, the statutory position and the underlying policy requirement of filtering and protecting this court from swathes of cases coming to permission to appeal leave applications remains exactly the same as applied in Dunn. And there's no principal difference between it. And the only difference is the mere fact that by virtue of the route of the criminal justice process, Dunn is a second tier appeal. But it makes no difference to the principle, and the court and the parliamentary intention of protecting the court remains the same. The alternative is if one removes the certification or in some way in response to the applicant's argument seeks to hurdle the gate that the legislature has provided by way of the certification requirement, then this court will be faced with a lesser degree of protection from frivolous cases, and even less than the extreme of frivolous cases. Cases where
I wonder whether you can really make that argument. If it's a frivolous appeal, it'll be dispatched fairly promptly by this court.
Well,
not only is there protection in the form of the convention that lower courts do not normally, in fact, only in exceptional cases will they give permission to appeal. Therefore, this court controls the cases that come here. And as well as that, of course, in order to apply for permission to appeal, certain costs are incurred. So I really don't think that there's a harbinger of, as you have put it, a swathe of frivolous appeals if the applicant succeeds in this current mission.
The point I was going to make, Lord, is that while one extreme of it is the frivolous appeal, but of course the rule of certification is wider than simply just the frivolous appeal. It's also a question of whether there is a point of general public importance and whether it should be heard at this time. Okay. So there is a wider stream of cases beyond the mere frivolous, important as that might be, that Parliament has, in its wisdom, decided this court should be protected from, in order that this court can focus its efforts on assessing those cases where there has already been a step reached. In other words, the court that has dealt with the matter below, under the type of approach identified by Lord Justice Golding, looks and considers, well, we're not dealing with the merits of the appeal, whether there should be leave or not. That's a different exercise. We're simply looking to consider whether this is a case that meets that style, gets a foot on the style over the gate. So Parliament has set that as a requirement, and we respectfully say that there is no domestic rule of law. My learned friend will come to the convention point.
I don't quite understand what you're arguing or trying to meet, because as far as domestic law is concerned, if you forget about the convention, we've got Gelber and Miller, which deals specifically with this form of clause, and it's pretty clear, I'd have thought. I mean, it's really only because we got since then had the convention, the one tries to look at that in wider terms, but you're not addressing the convention. So.
No, I'm not going to, or not directly in that sense. Yeah. Really, I suppose our point is the filter remains important. The filter's there for a purpose. There's a clear policy reason.
Yeah, but I mean, your point is not whether there's a policy or not, but there's a clear statutory provision upheld by the House of Lords.
The statutory provision reflects the underlying policy. That hasn't changed, and there's no reason to consider it has changed. And in fact, the only, respectfully, we would say, really the only way it can be seen to be broken down is if there is a convention requirement so requiring it. The only point I might make in relation to that, without trespassing hopefully too much on Dr. McLeanan, is on the issue that the court has raised with Mr. Lavery this morning as to what should be done if, in fact, it were to be deemed that the certification process should be read down or a declaration made in respect of the certification process. And if there's a declaration of incompatibility that comes into play in respect of that, the problem, I think, for the court in terms of the way forward is that it's then a question as to how the legislature reacts to that. There are various different ways the legislature might deal with that. It could simply remove the certification requirement and still leave the appeal route to this court, or alternatively, it could do what was suggested, for example, in the McDermott report. You'll see reference to that in January
Yes,
27.
allow an appeal to the Court of Appeal.
Exactly.
And then the Court
reverse
of
the
Appeal
entire
could certify it.
150 years of practice of keeping the Court of Appeal separate from incidental criminal appeals.
Yes.
So there are different routes depending on the parliamentary reaction if that approach is adopted by this court. The further slight complication perhaps in respect to that, and my Lord Converth made the point about Parliament's rather busy at the moment and it's got a lot of things on. In actual fact,
I'm not sure we can
I'm
take
quite
that.
sure.
I
Lord
don't think for one second that you're going to take that into account in deciding how you might deal with it. Of course you can't. But the further slip to that might be that, and I'm not sure that we've all perhaps directly addressed our minds to it, but it would seem to us that there is a strong likelihood that in fact the issue would fall within the legislative competence of the Northern Ireland Assembly. And that gives rise to a whole different panoply of difficulties and issues which I won't dilate upon this morning, you'll be glad to hear. So in summary, really our position is there's no need to change. The domestic provision is as was. The parliamentary intention remains the same. Parliament's had the opportunity to change this on several occasions in the modern age, following from the McDermott report in the context of Northern Ireland. There's also reference, I think, to another committee report within England and Wales. And indeed, of course, whenever this court was established under the Constitutional Reform Act in 2005, that would have provided a very opportune vehicle to make that more fundamental change if it wasn't taken. So from our perspective, we say that the court should respectfully find against the applicant on this point, and the appeal, the application for permission to appeal should be brought to an end on that basis.
Thank you very much, Mr. Cole. Now, Mr. McGleeton.
My Lords, my Lady, as Mr. Cole's indicated, I'll address the court briefly in respect of the convention issues. The applicant is faced with formidable hurdles in this case: a primary act of Parliament, rule in Lane and Easdale, Gelberg and Miller, Supreme Court's practice direction, all of which give a straightforward answer to the question that's raised. This applicant has no right of appeal to this court. The only way through would be, as my learned friends' characteristic ingenuity, is to find a way to apply the convention to open up the door, which is, we say, firmly bolted shut. And it is an issue that has been addressed in convention jurisprudence, both in the Strasbourg court and by our own domestic courts looking to the issue. And one can, from the jurisprudence, extract a number of basic propositions, and I'll sketch those and develop some of them. The convention rights relied upon here are Article 6 and, to a subsidiary degree, Article 8. Article 8, I'll come to in due course. Article 6 does not require a right of appeal in general terms. Where a member state does provide a right of appeal, then the application of Article 6 depends on any special features of the domestic legal order, and I'll come to that with reference to the fact that we're dealing here with the unusual jurisdiction of the divisional court on a criminal cause or matter. There can be limitations to a right of appeal even where it is afforded, and that will require analysis of whether it pursues a legitimate aim and doesn't infringe the very essence of a right of access to the courts. The fair and efficient administration of justice is such a legitimate aim, and the ability of the apex court to control its own docket and to deal only with those cases of particular importance with respect to points of law is a feature of that legitimate aim also. So we say that when one looks at the jurisprudence, a right of appeal to the final court can probably be limited by way of filter rather than bar in a means that does not breach the Article 6 safeguards.
But it's an interesting circumstance that there's a distinct contrast between the jurisdiction of England and Wales and the jurisdiction in Northern Ireland.
Yes.
Where there is a right of appeal to the Court of Appeal, which then applies the filter, as you put it.
Yes.
Whereas here, the court which decides the issue can effectively shut off the possibility of an appeal
Yes. We say that the two-tier appeal issue, which is probably the high point of the applicant's case, is something that is distraction when it comes to the question of principle. Both in Northern Ireland and in the situation that operates in England, the merits will have been considered by the first-tier court. It will have formed a view about whether there is a point of law of public importance requiring certification, and that is sufficient, we say, to meet any Article 6 requirements. It isn't necessary to have a second tier, and indeed, the jurisprudence doesn't state as a matter of principle that that's ever required.
No, but in England and Wales, if you are prosecuted and convicted, and provided you are given permission to appeal, you have an appeal right before the Court of Appeal before the certification issue arises. Isn't that right?
Yes.
Here, by contrast, you don't. The court that decides that you have no substantive case to make also decides that it doesn't give rise to a point of law of public general importance, which interestingly is precisely what the Supreme Court addresses first when it's considering whether to give permission to appeal.
Some insight, I think, to this can be gained by looking at the Protocol 7, Article 2 jurisprudence, which is what underlies the various Strasbourg cases to date, because Protocol 7, Article 2 of the Convention is the right to review in respect of a criminal conviction. Mm-hmm. And it's interesting when one looks at the actual text of Protocol 7, which has never been patriated into domestic law. We don't have it in the United Kingdom, and it's a curiosity of all of these papers that we don't have the text discreetly, but if you find MS page 700, you'll see Protocol 7 set out there in the text of the Dunn case. And this is the standard which is then used to inform the discussions in the various Strasbourg cases. Everyone convicted of a criminal offence by a tribunal shall have a right.
Which page are we on?
Sorry, page 700 at letter A. This is the Dunn Court of Appeal decision, tab 25.
Your point is that this is a right confined to those who have been convicted of a criminal offence.
And then, my Lord, also, if one looks just at the content of the right is to a review by a higher tribunal, not expressed in terms of appeal, but a review by a higher tribunal, single higher tribunal, not two tiers. And it then goes on to say, the exercise of this right, including the grounds on which it may be exercised, shall be governed by law, which is a reference to the modalities of the member state. And you'll see that picked up if you look across the page to the top of the next page. Sorry, it's in page 703. Paragraph 26 of Dunn, there's a reference to Jacobson in Denmark and a discussion of Protocol 7. The article does not specify its scope or actual implementation. The reference to the grounds of the view to be governed by national law clearly shows that states have a discretion as to the modalities for the exercise of the right of review. It's this part of the article which gives the states the possibility to limit the review in several ways. So we're a number of steps removed from all of that. That's not part of our domestic law, but our Article 6 analysis is informed by that, because that is what generates the jurisprudence, and at its height, it's talking about a single-phase review in a case of a criminal conviction.
Well, if this was applicable to the present case, I mean, I do appreciate that your principal argument is that this emphasises that the right to review is confined to circumstances where someone's been convicted, but just on the premise that there is some analogy to be drawn between someone who's been convicted and someone who stands at risk of criminal proceedings. If we take that as a premise, this quotation from the Commission suggests that it's possible to limit the review in several ways. I suspect what Mr. Lavery would say is you're not limiting the review here, you're eliminating it altogether.
Well, one of the ways in which it's legitimate to limit the review is by imposing not a bar but a filter. So there's still a prospect, the scheme, the broad scheme, which we're trying to look at the scheme, of course, broadly. The scheme still allows for access, and that's what we say would meet the international law standard. It may be that in a given case, one properly reaches a block because of the application of the filter, but the scheme still satisfies the test. And one can see that in the jurisprudence that follows. In Strasbourg, there are a number of cases that have dealt with the United Kingdom's domestic law provisions.
But none which deals with the current situation.
None that deals exactly with the current situation. Probably the most recent and the high point of the jurisprudence is done in the United Kingdom, tab 34. Mr. Lavery's taken you to that already.
Yeah.
And it is right that these judgments, and I think there are three now, which all looked at the Section 33 Criminal Appeal Act. And of course, there is a two-tier second appeal situation there. So one sees the language of second appeal threaded through these judgments. We say that's an accident in the sense of the scheme that's being examined there, rather than a principle in itself. And if one's searching for the principle, we say the principle is to be found in paragraph 38 of Done in the United Kingdom. That's MS 769. The court concludes, whilst a certification requirement undoubtedly restricted the applicant's access to the Superior Court, this fell within the respondent government's margin of appreciation and was proportionate to the legitimate aim of the proper and effective administration of justice. And as my Lord Carnless identified, that's an admissibility decision. The point was found to be unarguable in Dunn. We say that's equally applicable to the situation we have in the current scenario with the divisional court case.
Could I just ask to be reminded, when does the High Court of Northern Ireland sit as a divisional court? I mean, will there be criminal causes of matters which are dealt with by single judges?
Will only be dealt with by single judges by the consent of the parties. And sometimes for the leave hearing, it may be dealt with by a single judge, but almost inevitably, there will be a full panel of the divisional court which will sit on a criminal cause or matter judicial review.
So you could have leave to bring judicial review proceedings refused by a single judge who could then certify or refuse to certify?
That's possible.
Well, why would the parties not be competent to give consent to a single judge dealing with an application for leave to apply for judicial review?
They can do. Yes, they can consent to that.
And in those circumstances, if the judge refused leave to apply for judicial review, well, he might not have to address the question of certification at all, because if he refuses leave to apply for judicial review in his divisional court capacity, there is no right of appeal at all.
No, just check that. Isn't there? Back to that, informed by my colleagues searching through Order 53.
Well, I think that probably follows inexorably, does it not?
It does seem to me possible that this provision was designed to protect the smaller resources available to the Court of Appeal.
Yes.
Of Northern Ireland,
Yes.
where they have one constitution generally sitting.
Yes, that's right. And of course, again, the divisional court jurisdiction it's a matter of subject debate in another context in this court, but it is always, as my own friends have pointed out, the case there will be collateral criminal proceedings.
The satellite point, yes.
So the idea of the Protocol 7 issue will always be addressed in the context of the collateral criminal proceedings if they go anywhere. If this case ever goes anywhere, that's an open question. The applicant will have recourse to full panoply of appeal rights, entirely Article 6 compliant process. So in that context, we say, what is there that jars with paragraph 38 of Done in the United Kingdom? It's a matter of principle. There is nothing, because the access to the Superior Court is restricted, but in a manner that is proportionate. And one must look to the entirety of the scheme, not just the individual application itself. There's authority to that effect in the decision in the RMB, which is at tab 33, MS 759.
Yes.
Paragraph, second paragraph from the bottom. The manner in which Article 6 applies in relation to appeal proceedings depends on the special features of the proceedings involved. Account must be taken of the entirety of the proceedings in the domestic legal order and the role of the appeal court therein in the case of leave to appeal proceedings. And the nature of those proceedings, their significance in the context of proceedings as a whole must be considered, which is goes to my Lady Arden's point about what it is about the Northern Ireland jurisdiction, the nature of the divisional court proceedings there, the scale and scope of the workload they have. All of that's a factor for consideration. And we say, bearing all of that in mind, looking at it in its full context, in a case where the applicant would always have appeal rights, then the convention does not provide a way through. Point on process, the applicant goes at this in two ways. Applicant says Section 3 should be applied in order to give a reading. We say we never get there because there is no breach. But even if we did, the argument that he's putting forward in terms of a reading of Section 41 of the Judicial Act goes entirely against the grain of that statute. So it's not readily amenable, we say, to a Section 3 reading if the court was minded to take that course.
But I don't think you need to spend a lot of time on that.
No. Declaration of incompatibility, my lords, again, a minor procedural point, but these proceedings are not properly constituted in order to deal with the declaration of incompatibility. Neither of the respondents represents the Crown. Section 5 of the Human Rights Act requires that the Crown has notice of any application for a declaration of incompatibility so that they can defend the legislation.
Well, that's not a super problem.
No, that could be addressed, my lord, of course, if we got that far. But we say, as currently formulated, there isn't a basis for it. But in any event, we say the complete answer is found in Dunn, and we also say that this court has accepted that previously, because we have highlighted the decisions of this court on permission applications in the cases of Henry and Johnson, which are at 441 of the first volume.
Yeah.
It's in a landscape format and it's pithily expressed, but you will see that Henry and Johnson came before a panel of this court in July 18 on the Section 33(2) application, and the permission was refused. Why was it refused? For a variety of reasons, but at subparagraph 3 in the right-hand column, you will see this court found it was not arguable that 33(2) violated convention rights. There is no unfettered right to a second appeal. The limits imposed by that section are proportionate to the legitimate aim of the effective administration of justice done in the United Kingdom. We say again here, the second appeal is something of an interloper in terms of principle.
But you'll be conscious of the well-established jurisprudence that refusal of permission to appeal is not to be regarded as having precedental value.
Cognizant of that, my lord, yes. But I suppose we rely on the court's adoption of the done in the United Kingdom analysis, which is our core point in respect of Section
Right.
38. Just to direct the court's question about the jurisdiction of the Divisional Court in Northern Ireland, the relevant provision is Order 53, Rule 2. Lord Kerr will recall it well. It's at MS page 872, which sets out the circumstances in which that court can compose itself as a court of 1, 2, or in some circumstances, and most circumstances now 3 judges sitting together.
Mm-hmm.
Sorry, did you have a page reference for that?
872, MS 872, my lady.
Thank you.
So, finally, the subsidiary point in respect of Article 8 of the Convention, our point here is simply that the applicant overstates the Article 8 issue insofar as the Divisional Court and the Court of Appeal in Northern Ireland have both looked at this in the context of these ILOR requests. Their view has been that you approach it on the basis that it could amount to an interference with Article 8 rights, but that it was readily justifiable. So neither our Divisional Court nor our Court of Appeal have found there to be a breach of Article 8 through this process. They have worked on the basis, or an assumption that there may be an interference, but that it was readily justifiable. And we say there's nothing in Article 8 that would compel this court to take the course that's suggested by my learned friend to declare the provision to be incompatible, or indeed to read it down.
Yeah.
Lords, lady, those are my submissions, unless...
Thank you very much indeed. Now, Mr. Lavery. You don't have to reply.
No, I know that, and I will be exceedingly brief. In the context of proportionality and the legitimate aim of this provision, the Lord Chief Justice Morgan in JR 27 at MS 277 in his dissenting judgment on whether that was a criminal cause or matter indicated at the bottom of the page, in this jurisdiction there is no reason to believe that the provision of a right of appeal to the Court of Appeal in such cases would significantly increase the workload of the court. requirement to appeal directly to the Supreme Court now seems anomalous. So, and that coupled with the McDermott report and the report from Lord Johnson referred to in Dunn must seriously undermine any legitimate aim or proportionality or relation in this provision.
Should we look at that? What page was that?
That was in the McDermott report is referenced in JR 27, which recommended abolition of the provision. Begins in a section beginning at MS 261. And at the top of page 262, the judgment of Mr. Justice McCluskey said the McDermott Committee's proposal, while certain aspects of the jurisdiction of High Court could be exercised by two judges, divisional courts would be abolished, with the Court of Appeal having jurisdiction to hear and determine appeals from any judgment or order of the High Court. In the event the 1978 Act did not reflect this recommendation, there may well be a case for reinstating this proposal now, and as regards this issue, there is unanimity of opinion amongst the members of this present Chamber of Judges, so that includes the Lord Chief Justice. That should be looked at. And Lord Runciman in the Royal Commission in
But if is the appointment of judges something that's dealt with in Northern Ireland, or there could be delays, couldn't there?
So,
In fact, the Northern Ireland Judicial Appointments Commission precedes the appointment of the Commission in England and Wales and in Scotland.
But it still needs ministerial.
Oh yes, it still needs ministerial approval, yes.
hear that we're progressive on one issue, my Lord.
Right. Anything else, Mr. Lambert?
Unless there's anything else I can assist the court. The Johnson-Henry cases were second-tier appeals.
Yes.
And the declaration of incompatibility in the notification is not an insuperable.
Thank you very much indeed. We'll rise for 5 or 10 minutes and we'll return hopefully with our decision on this application.
Rise.
Well, we're very grateful to Council for the economy and skill of their presentations, the respective presentations. It's a very interesting point, but we have decided that permission must be refused. There's no need to rehearse the debate that took place between Council for the applicant and the bench concerning the proper interpretation of the relevant legislative provisions. When I say that Mr. Lavery deployed his argument on the proper interpretation with ingenuity, that is not meant to be in any sense insulting. To the contrary, I thought that the arguments which we have ultimately concluded cannot prevail were ingenious in the better connotation of that word. But ultimately we have reluctantly concluded that they cannot avail. It's not without significance that this question has been considered a number of times by the Executive and the Legislature, most recently in the Constitutional Reform Act of 2005, when the opportunity arose for a change to the order in Northern Ireland and was not taken. And of course, it's against the background of the report by a very distinguished former Lord Chief Justice of Northern Ireland, Lord MacDermott, and we have therefore concluded that the arguments based on the interpretation of the legislation simply do not meet the criterion that is required for permission to appeal to be granted. And therefore, the applicant is cast onto a reliance on the jurisprudence of the Strasbourg court. Again, a very fruitful line of argument was deployed, but we're satisfied that nothing in the various decisions to which we have been referred distinguishes or could be properly regarded as distinguishing such cases as done from the present, the circumstances Mr. Cole and Mr. McLean have submitted. The circumstance that in Dunn the courts were dealing with a second appeal rather than a first is entirely incidental to the gravamen of the conclusions that were reached, and we're satisfied that in relation to the European Court of Human Rights jurisprudence, likewise, the standard required for the grant of permission has not been reached, and we must therefore dismiss the application for permission. The court is now adjourned.